Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-7055, Tiffany Washington, Appellant versus Washington Metropolitan Area Transit Authority. Ms. Rucker for the appellant, Ms. Cole for the appellate.
Ms. Rucker, good morning. Please proceed.
Thank you, and good morning, Your Honors. May it please the court, Donna Rucker on behalf of Tiffany Washington, and we are before the court today, Your Honors, to assert that we believe that the trial court erred when, in fact, it determined that the termination claim contained in Ms. Washington's third charge somehow or another was a duplicate of what she had in her second charge and therefore could not proceed and go forward in this particular case. And we assert this contention for several reasons. First, while we note and recognize that in Ms. Washington's second charge at issue here, there was a mention of her termination, we believe that the record is clear that if you review that second charge where termination is actually indicated, it is certainly not properly presented to the EEOC such that it provides notice to WMATA or satisfy the standards of what needs to be stated for exhaustion. And specifically, there are simply generalized statements that are indicated within the second charge, compared, however, to the third charge that was timely filed within the time frame of Ms. Washington's termination, and specifically asserts what is needed to put WMATA as well as the commission on notice, which is considered to be a very important element of presenting cases to the EEOC. If these cases and claims are stated, but not properly presented, showing a prima facie case or setting forth allegations that will allow individuals to know what is being asserted and what is being contended, it is not, I would argue, properly before the commission. And such is the case with respect to the second claim. The third charge presented by Ms. Washington specifically identifies termination, and it is undisputed. It is uncontroverted on this record, both by WMATA and by reference by the court in its order that the termination charge is timely presented in the third charge. What is at issue here is the
termination charge was presented in the second charge.
It was actually indicated, Your Honor, as I stated. It was indicated in the second charge. Our position in this particular case is that the checking of the box or the indication of it alone did not satisfy the standards of presenting it and having it properly before the commission. Several claims are challenged, as is done by WMATA and other defendants in court, when a plaintiff makes statements either in a charge of discrimination or a complaint that does not properly state a claim. And that is what is contended here with respect to the second charge. It is
your strongest authority for that.
My authority for the exhaustion factor in terms of it stating properly a claim. Your indulgence, Your Honor. We would look at how it is distinguished in what Cooper versus Xerox, which we reference in our brief, basically indicating that merely checking a box or even failing to check a box does not necessarily control the scope of the charge. And so what we're saying here is that it is presented in the third charge, the fact that the termination was part of what she's claiming. It specifically states the bases. There is also a retaliatory hostile work environment claim that is submitted in the third charge that was not a part of the second charge. And the court in this particular case, as we review the order, specifically indicates that, that the termination being a discrete act may not have serve as a basis, but the court doesn't reach that point because it concludes that because the third charge references a termination that was part of another charge, the second charge, it is therefore stale. So the court never reaches the decision as to whether or not a continuing violation could advance both the termination claim as well as those other claims that were.
Were there any facts in the third claim that were within 180 days of that claim other than the termination?
I think the record is clear in this case, Your Honor, that the other claims are both in 2018, there are three different points, which would be 2018 dates. And so in order for those claims to be actionable under a hostile work environment continuing violation under Morgan, they would need to be a part of a current claim. And what we are articulating is that current claim is the termination claim, which, as I stated, is undisputed as being timely for purposes of presentation to the commission. It runs into a particular issue according to the trial court because it somehow or another was an attempt to, quote, revive, end quote, what was placed into the second charge. But we argue that it is very significant to recognize that this particular situation is quite different than what was argued by WMATA and referenced by the court, in that the cases that were referenced speaks to situations and circumstances where a right to sue letter was received, the 90 days expired, and counsel went back in to get a second right to sue letter. In this particular case, that is certainly not what we have here. And therefore, we argue and present that the floodgates are safely closed with any concern that you may have, excuse me, litigants trying to go back and get multiple right to sue letters so that it could advance a claim where a 90-day period has passed.
Now, is the Cooper decision your best authority?
Well, it is the authority. With your indulgence, I believe we would stand on the brief, Your Honors, with respect to the other authorities that we cite. I think the judge, and if you would indulge me, specifically says, and this is at A362 of the joint appendix where I'm reading from the opinion. Again, your indulgence, Your Honor. Oh, excuse me, it's A360. And the court actually references that prior to bringing a civil action under Title VII or the Rehabilitation Act, an employee must exhaust her administrative remedies, excuse me, by filing a charge with the EEOC within 180 days of the alleged discriminatory incident and file suit within 90 days of the final administrative action. And that's
basically what I'm trying to understand is we don't even have to get into the subtleties of whether you knew about the claim at the time you filed, if you knew about the charge at the time you filed a second claim, because you did, and it's stated there, but it wasn't stated adequately, you say.
That is correct, Your Honor.
It's not a situation where your client became aware of information that was previously unavailable to her. And I guess I'm not clear as to why the usual rule that you have a window to file and you either successfully file and make your claim or you don't. Your theory, I think, something about, well, complaints can be dismissed without prejudice. True, but that's a different situation. And I wonder whether or not here we don't have a situation where she knew about the termination charge that she could have brought and she didn't. And so now she wants to come in later and raise this. And so I don't see any end to this sort of theory of yours.
So I can give you where the end is, Your Honor, and that is specifically where the question or the issue here is that at the time that Ms. Washington is presenting her claim back, it is still a timely claim. This is not, I mean, even if—
Doesn't matter is what I'm getting at under the usual rule, that it may have been timely in your theory of the case, but as far as what she knew when she filed the second charge, didn't she have all the information she needed and for one reason or another checked the box but didn't do what she had to do? And isn't she bound by that action? It's not as though she learned something later or there was some infirmity that prevented her from presenting the claim properly as part of the second charge.
And so what I would say, Your Honor, to that is this is a situation where even if Ms. Washington knew that she was going to be terminated, she did not know all of the particular facts related to how that came about. She specifically states in that second charge, I don't know the details about this.
But that's not because she didn't explore it, all right? She knew about it.
She knew about the
like sort of
termination.
the discovery. You say there's an end,
Yes.
but I don't see the end in your theory.
I'm trying to get there, Your Honor, with respect to pointing out that when she brought, and I see that my time is up. May I continue?
Go ahead.
Thank you. When Ms. Washington brought her charge the third time, she was fully aware of all of the circumstances that caused her to believe not only was this a wrongful termination, but it was a discriminatory and retaliatory termination that was part of a continuing hostile work environment, and was such that she was able to fully and completely articulate what it is. She would not have had that opportunity if, when she was trying to present her third charge, that the timeline for making that claim had expired. That is not the case here. So that brings, Your Honor, the end to what you are speaking about. Had Ms. Washington attempted to come back with this third charge and her timeline for presenting it had expired, that presents the end that we are speaking about. But we do not stand on saying that all of the facts that establishes, especially when you look at her saying, I don't know all of the details. She is specifically saying that in her second charge. By the time she's submitting her timely third charge, and again, it's uncontroverted on this record that her third charge for termination was timely. She was able to articulate fully not only discriminatory factors, but factors that would support a retaliatory hostile work environment claim. And in doing so, not only does it present the discrete claim of termination, but it also allows for that event to be a part of the older claims of a hostile work environment or unfair treatment under Morgan.
But what procedure, if any, would there have been for her to amend the second charge rather than file a new third charge?
Okay, so she would have had an opportunity to, the right to sue letter had already issued. This case, as we can see, is not a situation as being concerned that we are concerned about, or I should say the appellant is concerned about, or the court should be concerned about with respect to opening the floodgates, or as Judge Rogers indicated, that would somehow or another not have an end. There is an end, as stated, and it doesn't open the floodgates because in this particular case, we're not getting a second bite, so to speak.
What is the answer, though, to the judge's question?
And so that's what I'm trying to get to. So I'm sorry, Your Honor, can you give me the question that you asked?
So you're saying that because the right to sue letter had issued on the second charge, you couldn't amend it any further at that point, right?
Well, if I'm remembering correctly, the right to sue, actually, the complaint in federal court and the third charge were pending at the same time. So there's this undercurrent notion that this process is being used to circumvent the timeline requirements of filing and getting a 90-day notice and then using it. But we were not motivated by that. And that is evidenced by the fact that when you look at the actual complaint that ultimately got dismissed, the third charge was pending within the EEOC. It was present in there. So it wasn't a stopgap action. It wasn't something done to come back and try to react to a dismissal and get a second bite at it. It is actually analyzing the particular facts and holding and standing on what defendants do every day in the court, is look at a charge. Had Ms. Washington's charge proceeded as was stated, it would face and did face a motion to dismiss, or could have a motion to dismiss for failure to state a claim and not being properly exhausted. And then we go to Your Honor's point of, can you amend it? And that's the question. That's the end point that I'm pointing out for the judge. Either you can or you cannot. And in this instance, Ms. Washington—
If we conclude that the second charge would have been sufficient, then do you lose?
If we conclude that she had properly articulated a termination claim in her second charge, then she would not be, she would be arguing duplicatively in her third charge. That is correct, Your Honor. And the catalyst here, the point here is there is simply an, so to speak, honorable mention of a wrongful termination, but no facts, circumstances, or allegations that would support. And the court, of course, did not reach these issues when we presented the case at bar, because the judge concluded that the reference to the termination in the third charge just simply made the actual case not one that could proceed as a matter of law. And so the actual idea of 90-day timeliness, or whether or not it was a meritorious claim that could be advanced, or whether that first or second charge had a proper claim, never actually got addressed by the court. But in
So
this
as
particular
far as
case,
you're aware, is there any rule of procedure that would have denied you the right to amend as part of the second charge?
what my understanding is, you know, I'm happy to provide any authority subsequent to this argument.
But you don't have any right now. I just want to be clear.
I don't have any authority right now.
All
but
right. So there's nothing that you know that would bar you from doing that.
Well, I would argue, Your Honor, that I'm barred once the commission dismisses the case. It no longer has the case. That case is gone, and there's
I
nothing.
know, and that's what I'm getting, the analogy in civil litigation. Here, she knew about the termination, and the fact that she didn't do her homework before she raised it in the second complaint, that's not something that she can rely on.
But it
She doesn't know all
presupposes.
the facts, but she
But
could
it-
have filed it and then filed a motion for particulars or something like that. In any event, I'd like to hear from Appellee counsel. Maybe she can answer Judge Wilkins' question specifically.
May I offer, Your Honor, as a final point, that it presupposes that this information was available at the time that she presented her.
She
second-
was terminated,
Oh, correct.
all
But
right?
we-
So she can investigate why.
She can, but it determines whether or not she was able to do that prior to the dismissal of her
Why
case.
couldn't she?
But I'm saying it presupposes that she did it. She could
I'm
have.
asking why, if I'm dismissed from employment, why can't I find out why and on what basis before I file my complaint? And if the opposing party refuses, or prospective opposing party refused to provide that information, that's a different situation than we have here. In any
Well,
event, could we hear from counsel for Appellee?
And
And
if
if you
I,
get a chance to respond.
thank you, Your Honor.
All right, Judge Wilkins, do you have any questions?
No,
All right, then, Ms. Rucker, we'll give you a couple minutes in reply. And Ms. Cole, good morning.
Thank you.
Good morning. Thank you. May it please the court, Janice Cole on behalf of Washington Metropolitan Area Transit Authority. Your honors have identified the problem here in Ms. Washington's position. One of the cases that she herself relied on in her brief, Golden versus Management and Training Corporation, makes mention of the fact that the exhaustion requirement is simply that the plaintiff exhaust each claim. And it does not require the plaintiff to include all the evidence pertaining to each claim. And that is what Ms. Washington did. She could not, in fact, have done it any clearer. There are the boxes that she checked in the amended second complaint, which is at A101. And she checked the boxes for sex, retaliation, for disability, and race. In addition, for that very first charge, she checked the box other. And next to it, she wrote wrongful termination. And it's important to realize where this filing occurred in relation to the timeline. She filed it approximately 3 weeks after she was terminated from her position as a police officer. She received a medical disqualification to which she makes reference in this amended charge. She indicates that she was trying to appeal that she met with people in relation to that and to the process. And when you look at the narrative with the checked boxes, there is nothing more for her to exhaust. It is not a requirement that a claimant put every bit of evidence in a charge. And indeed, that is part of the discovery process later in litigation.
Well, what about her argument that she may have checked the box, but that's not enough to properly present a claim?
There was a case, I think it's Mills versus Hayden, that WMATA cited in its brief, which indicated that one of the judges in this district did a survey and could not find any case where the checking of the box was insufficient to exhaust a claim. Typically, our positions would be reversed in a Title VII claim. It's normally the plaintiff or the claimant who would be arguing, I checked the box, and that means all of this other additional type of related claim related to that box can come in. Checking the boxes.
Let me ask you in response to my question, just follow through. Has that been the position of the commission? That merely checking a box is insufficient? As far as giving adequate notice to the commission and the other party?
I am unaware of any authority saying that checking the box is insufficient, Your Honor. My position is that checking the box is absolutely sufficient, and that it's typically.
Well, what are you relying on? You say absolutely. What authority?
It was in Mills versus Hayden, where a judge of this district did do a survey in which 284 F 3rd 14 could not find any authority when there was a search in that matter where checking the box was found to be insufficient for exhaustion. Checking the box is more to the scope of a claim, not to whether it is exhausted or not. For example, as it could be whether a hostile work environment, because there's no box for that, whether it was encompassed in a claim because there's no box. And so that might be an issue. But here we have not only all the boxes checked, we have then the corresponding complaint that was filed based on the amended second charge. And that was in front of Judge Clark-Catelli. That had the exact same causes of action that were then later set forth in her third complaint, which is the subject of this appeal. There is no difference. They were word for word the same allegations as the dismissed complaint by Judge Clark-Catelli. And this is.
So what about, I guess, your friend on the other side's argument that, well, look, if someone files a charge and then let's say maybe they're uncounseled, and then there's a right to sue letter that issues, and they go meet with a lawyer at that point, and the lawyer says, well, I'm not sure that charge is complete, and since we don't have like Supreme Court or DC Circuit authority on point, and we don't want to have any issues with failure to exhaust, and we're still within 180 days of the termination, I'm going to file another charge that really lays out all of the details and particulars. And then when we get the right to sue letter from that, assuming that the EEOC declines to file, then we'll be protected because we can file our complaint after we get that right to sue letter. And it's not going to extend this out forever because you still have the kind of, it still has to be within 180 days of termination. So what's the big hardship or problem in looking at it that way?
So, Your Honor, the response would be first, the process is to amend the charge, which is what exactly this claimant did. She amended that second charge because before the amending date of April 25th of 2019, she had simply had the very first paragraph that she had been experiencing discrimination and harassment since while a police officer, and it was based on race and sex and retaliation. She then, after she was terminated, amended that charge to include a lot of information about leading up to her termination and the termination itself. So she engaged in that process as she should.
But in
by
my
including the charge.
hypothetical, after the right to sue letter issues, she goes to meet with counsel, and counsel is still concerned that it's not complete enough. And so they file another charge, because once the right to sue letter issues, you can't amend the charge, right? Because the charge has been, adjudicated, so to speak, by the EEOC at that point, right?
Correct, Your Honor. She is now within her 90-day time period in which she has to file. And the case law says, to the extent that there is other unexpired charges which are still timely and can be exhausted in front of the EEOC, then a claimant can proceed through that process, but they cannot overlap. And with the same charges, especially where we have a discrete act, and that's the only anchor event that is timely in this third charge. So sometimes we have a lot of moving parts to consider, but as a general proposition, in response to your question, and as Judge Lamberth said in Price versus Greenspan, one looks to the what is not stale and what is not expired and which has not been raised before. So to the extent that there is a right to sue letter that controls some charges that have already been exhausted, one cannot artificially extend that time period by refiling another charge, if that answers the question.
Thank you.
And here, that is indeed what the plaintiff attempted to do. Her motivation is not at part of the analysis. There was another issue. I don't know if the court's willing to hear because I see I'm out of time, but there was another untimeliness issue if the court would like to hear, but.
We have that on your brief. If there are no more questions, thank you. And Ms. Rucker, why don't you take 1 minute?
Thank you very much, Your Honors. So what I wanted to point out is, in response to this particular case, is the distinction between the information that is simply placed in a charge and an information that is presented to the commission. What is absent here is any charge of discrimination for termination or for hostile work environment, retaliatory hostile work environment being presented in that second charge. It is clearly present in the third charge. Both the court and counsel for WMATA acknowledges that it was timely presented. And this is a particular situation where the court, federal court, provided complainant an avenue and a vehicle to come back in with respect to her termination claim by issuing a non-prejudicial dismissal. And the right to sue letter in this case is not stale. It was actually issued on a properly concluded federal court charge with the EEOC, and this case should be allowed to proceed with respect to the merits and through discovery on the particular allegations here. Thank you all for your time.
All right. Thank you, Counsel. Madam Clerk, if you would call the next case. And Judge Wilkins, could you put a microphone on. I could not hear you. I couldn't hear your questions. Do you have a mic you can use? Oh, I can hear now.
Yeah, I'll try to speak up and see if I can locate a microphone.
Case number 21-1165, Eugene C. Ross, Appellant versus Securities and Exchange Commission. Mr. Cohn for the appellant, Mr. Rady for the appellate.
Mr. Cohn, good morning. Please proceed.
Good morning. Yes, my name is Steve Cohn. I'm the attorney for the petitioner Eugene Ross. This case raises three issues in which the commission committed error. First, in not finding original information. Second, in not finding Mr. Ross was voluntary. And third, not granting exemptive relief. In regard to the voluntary issue, the SEC improperly put a straitjacket on the concept of voluntary. And in so doing, they actually went against the three False Claims Act cases that they cited in their rulemaking to justify the current rule. They cited three cases also in their brief. The first was US XREL fine. And in that case, the court approved a dictionary definition of voluntary that is identical to the one that we were using. They used Webster's, we used Oxford, but applying that definition, Ross was voluntary. Second, in the case of Surgard, the whistleblower was involved in the fraudulent activity, and the contact with the government was initiated by a subpoena. In our case, it's the exact opposite. Ross had no involvement. He discovered it. He was the true original source. And the contact was initiated only after he worked extensively with the victim and her attorney. They met 16 times where he helped explain the frauds. In Surgard, they criticized the relator being complacent, reluctant, and delinquent. None of those apply to Ross, exact opposite. The third case relied upon by the commission in justifying its rule, Barth, is extremely enlightening. Because in that case, this is what the court says, that the voluntary concept was to prevent opportunistic suits by private persons who became aware of the fraud, but played no part in exposing it.
Counsel, I think that to me, your bigger problem than the voluntary definition is the fact that the statute defines original information in such a way to appear to be that it has to be provided after July 21, 2010. And it seems that the statute says that in both subsection B there of that pertinent section in the original information definition, and it also implies the same in subsection C about awards, where it says, well, you can get an award for a violation that happens before July 21st, 2010, so long as the information that you are providing is after that date. So why isn't that clear?
And Your Honor, first, I would agree that if the commission had found original information, I do believe they would have looked at voluntary differently. And I do believe that they would have looked at the exemptive relief differently. But going to original information, what your arguments, with what you're laying out, what the commission laid out, all made sense prior to the Supreme Court's decision in Digital. Digital changed the entire analysis. Why? Because what Digital said is in the statutory definitional section, not the regulation, the statutory definitional section, was unambiguous. You know, if it's unambiguous and precisely defines the term, the statutory definition of original information, which is a term of art, was precise, unambiguous. It met the exact standard that the Supreme Court identified in digital. And what's important about digital is the lower courts, the Second Circuit, which did Stryker, the Ninth Circuit, they did the precise analysis that the commission wants you to do here. But what the Supreme Court said unanimously, no, this is a specific definition. It uses the term means. And here's their words. Congress has directly spoken to the precise question at issue. Therefore, no deference should be given to the contrary view. As for the definition of original information, they spoke precisely to it. It's laid out clearly. And as the Supreme Court said, the commission was therefore quote,
That's my point. I think that it's laid out clearly, but laid out clearly in a way that means that the information has to be provided after July 21, 2010.
Well, Your Honor, if you look at the statutory definition, it has three components. Derived from independent knowledge, yes, Ross met that. Not known to the commission from any other source unless Ross was the source, yes, Ross met that. And not known from a public source, yes, Ross met that. That's the precise definition. Now, if you go back to digital, what you'll see is that there were other parts of the statute that supported the commission's interpretation of the term whistleblower. In fact, the retaliation section, which was at issue, actually had a definition of a protected disclosure that included internal disclosures. So what the commission said is that this part of the statute, the retaliation part, and that's what was at issue in digital, it defined a protected disclosure as going internal.
Well, I think we're understanding each other. So I understand your argument about the definition, and I should have been clearer. The definitions appear in section 76U-6. I'm talking about 76U-7 that talks about implementation in transition provisions.
Okay, so yeah, okay.
So that's the section that I think has to be read in conjunction with the definitions to understand what Congress meant when it said what is original information.
Okay, so that section, section 7, there are two things to keep in mind. One, they're creating a safe harbor for people who don't use the proper form to submit a claim. So what the commission is arguing that a safe harbor provision dealing with how you file somehow becomes a negation of a mandatory statutory definition. Second, and this is important, the commission—
Well, not mandatory, but a precondition. Even if you meet all the standards, you still have to file after this date. And if you didn't file after this date, your claim is not properly a whistleblower claim under the statute. Why isn't that the way to read the statute?
First is because the commission decided that he didn't provide original information. They did not issue a rule on the other provisions of the statute. And they didn't issue a rule. The rule at issue here interprets original information. And you may ask, why did they do that and not create a rule under subsection 7? The reason is, if you look at their rulemaking authority, it only goes to subsection 6. And this is what's very critical. It gave the commission tremendous authority to deny claims that are not submitted in the form required by the commission. That safe harbor provision prevented the commission from denying a claim that was not presented in the proper form between the time that the statute was passed and they did their final regulations.
I don't see how you can read that in that manner, counsel. I mean, section 6 sets forth the definitions. And then section 7 says, look, commission, issue regulations to implement this. And then that's subsection A, and then subsection B, it says, look, you can still present original information before those regulations are implemented, because we know that may take a while, just so long as it's after the July 21st, 2010 date. And then Congress uses the date again in talking about awards in subsection C to say, you know, if the violation is before the July 21, 2010 date, that won't preclude you from getting an award so long as you provide the information after that date, is the way that I read all of those things together. So, you know, I don't understand this whole thing that you're saying about, oh, it's just about whether there's some form that is properly complied with. It's all about how to implement the regulatory scheme.
Your Honor, I'm just essentially saying that's a plausible explanation of the power of subsection 7. They didn't issue a rule based on subsection 7. They issued a rule interpreting original information. And under digital, you just can't give the commission the benefit of the doubt. If they did one under subsection 7, it's a different case. But under digital, there's a precise definition of original information. It has 3 parts, and under digital, the analysis must stop there. That's our position, Your Honor.
So you're saying that when they did the rulemaking at issue here, they didn't cite subsection 7 as
no, they did not base a rule on subsection 7. They didn't look at subsection 7 and create a rule on timing of filing claims.
That's not my question. Did they cite subsection 7 as their authority for promulgating the rule? Yes or no?
That would be in the Federal Register. I could double check and see that. That would be in the Federal Register under this part. But our position is very clear. It's immaterial. Congress created a mandatory definition. When one looks at that definition in the context of digital, it's binding. When one looks at the fact that there are other parts of the statute that could alter that determination, what the Supreme Court said in digital, no go. You stick with that definition. And although it's a little nuanced, in the definition of a retaliatory action in the Dodd-Frank Act, there was a provision that says all claims under the Sarbanes-Oxley Act, which included internal. So the Supreme Court is looking at a statute that has one part protecting internal disclosures, another part in which defines a term. And what they said is the definition of the term is controlling. You don't even look at those other parts of the statute. And we think
All right, Judge Wilkins, has he answered your question?
Thank you.
Yes.
All right,
Thank
Judge
you.
Rogers, do you have any questions?
No, I've asked my question, and Judge
All right.
Wilkins has asked those questions as well.
All right, Mr. Cohn, then we'll give you a minute reply, but we'll hear from Mr. Rady now. Good morning.
Good morning, Your Honors. This is John Rady on behalf of the Securities and Exchange Commission. This court should affirm the Commission's order that denied Mr. Ross's whistleblower claim for either of 2 independent reasons, and I'd like to start with original information. With respect to that statutory term, the Commission at least reasonably determined that Congress in Dodd-Frank established a whistleblower program that operates prospectively in order to incentivize whistleblowers to come forward. This interpretation is supported by the text and context of the relevant statutory provisions. Most importantly, a statutory safe harbor in section 78U-7B that only protects information submitted after Dodd-Frank was adopted. And I'd like to answer a question that Judge Wilkins posed to my opposing colleague. The commission did cite this section in both its proposing release and the final rule. And those citations are in the proposing release, that's 75 Federal Register 70492 and footnote 20. And in the final adopting release, that's 76 Federal Register 34310, and that's footnote 94. The Second Circuit in the Stryker case relied on this provision and other statutory provisions to determine that the commission's interpretation was reasonable. Under those provisions, and as relevant here, Mr. Ross did not submit any original information after Dodd-Frank was enacted that led to the successful enforcement of a covered action, and his claim should be denied for that reason.
Let me ask you a hypothetical. Let's suppose that the date weren't at issue. And you had someone in Mr. Ross's position who discovers a fraud and reports it to his client and reports it to his employer. And they both say, we need to have, our lawyers check into it. Thank you very much. And we'll get back to you. And both the client and the employer contact the SEC with the information. And then the SEC reaches out to Mr. Ross. He doesn't call the SEC because he's been told by his client and his employer that they want to have their lawyers look into it first. But under the SEC's rule, he would not be acting voluntarily if he completely cooperated from that point because he didn't make the first phone call to them, even though he would still be considered to be the source and the originator of the information, right?
Your Honor, that is a correct interpretation of the commission's rule. And I think—
How does that make any sense at all?
Yes, Your Honor. I think if you look at the text of the statute using the word voluntarily, if you look at the context of the fact that this is a whistleblower statute, if you look at the legislative history, and I think specifically in the Senate report at pages 38 and 110 to 112, which is referenced in the Digital Realty, it's clear that Congress was trying to create a new whistleblower program that was going to incentivize whistleblowers to do one thing. As the Digital Realty court said, a core objective of Dodd-Frank's whistleblower program is to get people to come forward and tell the commission information. Nobody's arguing that it's a bad thing if Mr. Ross tells his client, tells his employer, but we're really what we're setting up this whistleblower program to do, and we're giving them a statutorily—
Well, the way that the rule would work would be if he feels like his obligation before he goes running to the SEC is to tell his client first and to tell his employer first, and he does so, and they say, thank you, we're going to contact the SEC now. He has to say, oh, no, let me call the SEC first. Otherwise, I don't get any credit for this. That's how this works. There's got to be like a race to see who calls the SEC first. He's got to not follow his client's wishes or his employer's wishes and call the SEC first. That's the way this is supposed to work.
Your Honor, I think this statute, is designed, as the commission said in its adopting release, I think it's also clear in the legislative history once again, it's designed to get whistleblowers to come forward and tell the commission information early. We do want to encourage people to—
If he tells his client about the fraud and the client says, I'm going to call the SEC, why isn't that completely consistent with the statute. He knows the SEC is going to be called immediately because of his actions. He's just the one, not the one making the call.
Your Honor, I think two answers to that question. I think the first is very similar to what essentially the last answer is that, again, I think what the commission wanted whistleblowers to do is phone the SEC. It didn't want to encourage people to go through more circuitous routes to get there. It wants people to just directly contact the SEC. And the second answer to Your Honor's question, and although this isn't a point that I think is that it hasn't come up in the context of this appeal, I think Your Honor's hypothetical is getting close to a situation in which it would be possible that two whistleblowers are acting jointly together. And that is something that the statute provides for. At some point, if it became the case that, hypothetical Mr. Ross's client here, you could imagine other hypotheticals. If they're working together to give the commission information, the statute will allow those two people to be considered joint whistleblowers for purposes of an award. Now, that's not relevant in this appeal. The commission rejected that possibility based on the facts here, but that would be something that would, I think, address some hypotheticals along those lines. Unless Your Honors have further questions about.
No, I thought of a financial one as well. Government doesn't want to pay whistleblower awards if it can get the information directly from the client or the employer.
Well, I think,
it's not a statute designed to employ attorneys and pay them awards. It's a statute designed to get the information fast in order to cut off any potential fraud. I mean, that's another way of responding, that it may not be the best choice from one point of view, but it is a choice that was deliberately made. And if it doesn't make sense in the long run, they can always ask Congress to amend that. But it's not as though the opposite view is nonsensical, that we would have to reject it, which I think is the underlying thesis of hypothetical. Maybe I'm wrong. Anyway, it's not before us.
Your Honor, I think that's exactly right, Your Honor. And I think if you look at legislative history, once again, it's clear that this is the whistleblower program here is something new that's meant to augment, what the commission has already been doing. So I think that's just another point that is exactly consistent with what Your Honor is saying. If there's no further questions on any of the points raised in the briefs, the commission is happy to rest on its brief.
All right, thank you. Mr. Cohn, why don't you take 1 minute?
Yes, thank you. Just very quickly on the voluntary issue, all of the exemptive relief cases would support having granted that for Mr. Ross. But more important, the 3 cases cited by the commission, their own rulemaking, all would support our interpretation. And specifically, the Barth case, which identifies whether they had a part in exposing it. They cite to the Wang case in that decision, which talks about directly or indirectly disclosing it. In regard to the original information, I would call the court's attention to the legislative history, the Senate report that says the law was based on the IRS law. The IRS law contained precisely what the commission did in the rulemaking. It had a date, said you must file after this law is passed. Congress did not include that provision in this law, even though they had it right in front of them when they drafted it. And there's case law that we have cited that says that would be intentional exclusion of that type of provision. Thank you very much, Your Honors.
All right, thank you, counsel. Madam Clerk, if you'd please adjourn court.
This honorable court is now adjourned until Wednesday, May 4th at 9:30 a.m.